To this story now, proceedings took an unsavoury turn during the cross-examination of Brigadier Bongani Gininda in the Senzo Meyiwa murder trial. This when the lead investigator was being asked about the possibility that one of the officers who took the confession statement of accused number 1 knew about the details of the case.
I think Colonel Mboto would have been the dumbest cop in South Africa to have said that at the time at which you requested him to go and do the confession, he had no knowledge about the death of Senzo. I withdraw the question.
We don't.
I withdraw the question. Thank you.
But that question...
I said I withdrew it, my lord.
Yeah, but you can't say something about an officer of the law that would have been the dumbest.
That's not an insult, my lord.
It is.
No.
So let's hope to behave ourselves. I mean, me, I'm being told, why ungabuzi lona? Why ungabuzi lona? I mean, you never address a judicial officer like that. If a judge makes a comment, you shut up. That's how we were taught. You keep quiet. If a judge has offended you, you ask to see the judge in chambers. You complain, fine. But this thing of arguing with the judge in open court like this, people see that you don't care for the judge, you don't even respect that judge. The same thing happens with witnesses. You may differ with a witness when he gives evidence, but respect his opinion. Now we're fighting every day here in this court. We're fighting about decorum, 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 decorum.
Well, let's discuss this now, and to help us understand what the conduct of lawyers should be in a court of law, we're joined by legal expert Abigail Ngobene. Ms. Ngobene, good evening to you. Thank you very much for your time. It is not the first time we speak about the conduct of lawyers, particularly in this trial pertaining to the murder of Senzo Meyiwa. Let's start with the generic question. What or how are lawyers expected to carry themselves in a court of law, including the language they use?
Okay, good evening, and good evening to you and to the viewers of Newzroom Afrika. Thank you very much for having me. It is a basic thing that one is taught, particularly when you are trained as an attorney, as an advocate, that you are an officer of court, and your behavior should somehow uphold a certain expected ethical standard that display and will draw public trust from those who are ordinary observers to say that, and we normally call it the court decorum, which needs to be observed by every officer of court, to an extent that we were taught that when the judge talks to you, you sit down. And if your colleague is talking, you sit down. When it's your time to respond, you stand. So it is new to observe in a court of law having an altercation where a judge will exchange words with a practitioner while the practitioner is on his feet.
And it is something that is, as I point out, is not happening for the first time in this trial. Does it talk to the temperament, or should we say the emotional intelligence of the officer of the court, and that is the lawyer? But what also is the duty of the judge to ensure that, to use the words of Judge Mokgotleng, that there is decorum in his court? How does he act in order to nip that kind of behavior in the bud?
I would particularly answer that question in general, not necessarily in an effort to try and pin on a particular behavior of a certain legal practitioner, particularly on the case we are talking about. But to be direct to your answer to your question, I would say that in an instance where a practitioner behaves in a particular manner, or in an instance where a practitioner feels offended by a particular comment, either be from the judge or a colleague, there are established channels of raising concern, and exchanging words with the judge presiding in a matter is never a solution. And another aspect to it would be that, particularly on this matter, I think emotions are flying high, and a level of stress may be very high given the volume of work that the advocate in particular had to do. And we have seen a lot of these things happening, particularly in this trial. I cannot necessarily speak to an emotional intelligence, but I can only speak to the stress level that is manifesting itself in that court. And I could only appeal as an ordinary observer from far to say officers of court who are involved in that trial should try to calm themselves, ensure that they convey their message either to the witness or to the court in a manner that is respectful.
You know, I'm not going to try and rehash the judge's observations about that kind of conduct, particularly on the part of Advocate Mnisi. But he did say, and I find it quite difficult, because this is where the standards are almost, it's almost as if you're comparing white lawyers and their conduct versus black lawyers. And that's what the judge said, actually, in not so many words, that we are probably watched by white lawyers to say, look at how they are conducting themselves. But I don't want to take the conversation there. I want to keep it at the professional conduct and ask the question, if a lawyer conducts himself or herself in that fashion, that lawyer, do they risk not getting work from people who may possibly want to resolve matters in court? All I'm saying is that, does it have a reputational damage for that lawyer in terms of getting future work? If you're going to conduct yourself in such a fashion, you obviously are not selling yourself to the general public, particularly if TV cameras are there.
Unfortunately, being an attorney or being an officer of court, you are expected to uphold a certain level of ethical standards and conduct, which, when people look at it, they can summarize the integrity of the justice system by looking at you on how you conduct yourself. So there is a general expectation that an attorney or a lawyer or a judge should behave in a particular manner for the public to have confidence on what we do. So to answer your question, I would say that it cannot really be that a blanket approach to say you will lose clients. Some can interpret that as being a person that stand your ground, but some can interpret it to say you cross the line of respect, you cross the line of what a person should be. Remember that before you are an officer of court, you are a human being, and a human being has to also uphold a certain level of respect. The spirit of Ubuntu is something that comes naturally, and if you can't respect, likely some other people may not want to associate with you. But I cannot say that that will qualify you to lose briefs or instructions. But one would say that it is expected from a legal practitioner to behave in a manner that enforces or enhances respect for the court of law.
Abigail Ngobene, thank you very much for your time and analysis